Hey guys, personal injury attorney Jerry Parisi here, and today I'm going to go over the steps to a personal injury case. I'm going to talk about the process and the timeline of the general steps that a personal injury case takes once you sign up with an attorney. And this is just general, the steps could be shorter, there could be more, but generally this is how a case progresses. And the reason I'm talking about this is because almost every client that comes into my office, if they haven't been in a car accident before, they have no idea how the process works. They tell me they don't know and they just want to hear it from me. So this is what I tell them. And I'm just giving you this information just in case you're curious, or if you have a case, here's how it kind of works and the time frame that it takes in general. So number one, when you hire a lawyer, what we do is we set the case up. So we send out notices as required by law to anybody that's involved. All the insurance companies that are involved that may provide coverage. So not only the driver that hit you, their insurance company, but your insurance company in case there's a potential claim down the road for what's called uninsured or underinsured motorist coverage. And UM coverage is what we call it. And we don't know right at the beginning of a case whether that would apply. But if it does apply down the road and we didn't send the proper notice, that could destroy your UM claim. So that's something we always do. As a matter of course, we notify your own insurance company of a potential UM claim that may be coming down the road, or else they may deny coverage at a later date. And we don't want that to happen to you. The second thing we do, stage 2, is collect evidence. So we're going to get a copy of the police report. If we need to hire an accident reconstructionist to go out there and prove what happened, get those facts, get that data. We're going to talk to witnesses, see what they saw, get affidavits from people that may have been there or seen what happened. And we're just going to collect all the evidence that we can. And during this time, you're going to be in phase 3, which is the treatment phase. You're going to seek medical treatment. You're going to go to your doctors. If your doctor refers you to any specialist that you may need to see, you need to go. And this is the phase that it's a wild card. It could take, a month. It could take a year. And we just don't know. It just depends on you and your body and how long it takes for you to reach what's called maximum medical improvement. So once your doctor tells you that you've reached maximum medical improvement, they'll release you. And then you'll tell us, or we'll be following up with you just in case. And then we'll get the ball rolling on the next phase, which is collecting all of the medical records and the medical bills. So once you're done treating, it takes us time to send out those requests, and we're going to obtain all the medical records from your providers. And we do that. We get certified records. We do that on your behalf so that you don't have to worry about it. And then we take those medical records, we take those bills and all the evidence that we've already collected. And in the next phase, phase 5, we put together what's called a demand. So we put together all the evidence, the liability, whose fault it was, all the treatment that you've received, all the injuries that you've had, and really how this accident and your injuries have affected your life. So it's not just, a lot of lawyers will tally up your medical bills and they'll say, well, give us 3 times what their medical bills were. Our approach is, how did this accident that wasn't your fault, how did the other driver's negligence affect your life? What damages did it cause that are non-economic, right? So not just your medical bills and your lost wages, but really lost time with family. You couldn't go on vacation because you were injured. Maybe you were depressed. Maybe you had some pain and suffering. All those things, we're going to get that story from you. We're going to put that together in what's called the demand package, and we're going to make a settlement offer to the at-fault driver's insurance company. We're going to give them an offer to settle the case within their policy limits. So it really depends on what the at-fault driver's car insurance policy, what the limits of that policy are. In Georgia, the minimum policy that a driver is required to carry is $25,000 per person and $50,000 per accident. So we send off the demand letter to their company, demanding, usually depends on the case, but oftentimes we'll demand the policy limits. And then they generally have 30 days to read the demand, look at the evidence, and consider the demand, and if they want to settle for what we've offered to settle for. If they do, they'll tender the policy limits or the other number that we've requested, and the case will be settled. We'll have you come in, sign a release, sign a check, and then the case will be finished. If they don't, if the car insurance company chooses not to settle the case for what we've asked for, if they make a counter offer, then we'll go into negotiations. We'll start negotiating on your behalf. We'll present the strengths of your case to the car insurance company, their adjuster. They'll present your weaknesses, and we'll just go back and forth and try to reach a number that you're happy with. If we cannot come to an agreement on a number that you're willing to accept, then we will consider filing a lawsuit. And now that's always done with your consent. We're never going to sue somebody without you consenting and agreeing to sue them. So we can negotiate with the car insurance company generally up until getting close to the statute of limitations, which in general for a car accident is 2 years from the date of the accident. So it gives us a long time to negotiate and try to come to a reasonable agreement without having to file a lawsuit. But if we just can't get there, and with your consent, you want to file a lawsuit, then we'll go ahead and draft a lawsuit and get that filed and serve it on the defendant, the at-fault driver, or any other party that is deemed at fault. And once we file that lawsuit, then that person has 30 days to respond. So they've got to file an answer to the lawsuit. And it's generally 30 days, but all these things in litigation, there's an exception. Generally 30 days. Once that 30 days is up and they filed their answer, we're then into what's called the discovery phase of litigation. And discovery is a fact-finding phase, an information sharing phase that generally lasts from 6 months after the answer is filed, which also there's exceptions to that. It can be extended for a number of reasons. But discovery is where both sides share the information and the evidence that they have with the other side. This is where depositions are taking. So you may have to give a deposition if you're the injured party. We'll also take the deposition of the at-fault driver, any other witnesses. If there's any medical experts hired by either side, those depositions will take place. And like I said, we'll just generally share evidence and information. And settlement negotiations can continue during this phase as well. After discovery, generally what happens, it's usually shortly after the depositions are taken, is we'll schedule a mediation. And what that is we'll sit down with a neutral third party mediator, and that person's job is to try to help us settle the case. So we'll present the strengths of your case, everything that we've already talked about. And the car insurance company, they'll have a lawyer there. They may have an adjuster from the insurance company there as well. And their job is to present the weaknesses of your case, or whatever they've come up with to say that is a weakness of your case. And the two sides will negotiate with the help of the third party mediator, and then we'll try to get as close to a settlement. Hopefully we can settle the case. But if not, if we walk out of mediation without a settlement agreement, the case will progress through litigation. So generally after mediation, discovery may continue a little bit, or we'll gear up towards trial. Now don't be scared if, your case is getting close to trial. Generally less than 5% of car accident cases ever go to trial. But even if your case does go to trial, that's not necessarily a bad thing. It's nothing to be afraid of. There's nothing scary about a trial. It's really just your chance to tell your side of the story, how this accident occurred, how it has affected your life, and really tell a jury of your peers, what we're asking for. It's our job to, tell them what numbers we're seeking, but it's your job to tell the story when you're on the stand. And like I said, less than 5% of cases generally go to trial, but it is the place where you're usually going to get the best outcome for your case. And when I say outcome, the most amount of money. Usually in a car accident case, if you take it all the way to trial, that's when a jury will award you the most amount of money that you're probably going to get. Not always, but usually that's what happens. And then the case is over, obviously, after you go to trial, unless there's an appeal. But I won't talk about that on this video today. So those are the general steps in a car accident case, in a personal injury case. And it differs slightly if it's a slip and fall or a dog bite case, but not too much. It's generally the same for every type of case. So just to go over it again, there's once you hire a lawyer, The first couple weeks, we're going to be notifying everybody, setting up your claim, setting up your file, doing a lot of legwork and paperwork and things that need to be done. After that, we're going to collect the evidence. Then you're going to go seek all the medical treatment that you need and that is necessary. Once you've reached maximum medical improvement, we're going to collect all your medical records and bills. We're going to put together a demand package and settlement offer to the insurance company. If that settlement offer is not accepted, we're going to enter negotiations. If those negotiations fail, we may file a lawsuit on your behalf. After the lawsuit is filed and the defendant answers, then we're in the discovery phase. After discovery is generally mediation. If the case still isn't settled after mediation, the case may progress toward trial. And that trial is generally the conclusion of the case unless there's an appeal. So those are the steps to a car accident case. Please like this video, save it for future reference, and like and follow our Facebook page for more useful law and legal tips. Thanks.